Welcome everyone to the webinar on the meaning of relevant for discovery purposes. I'm Tim Opsitnik. I am the Executive Vice President and General Counsel for TCDI. TCDI is a e-discovery litigation management and document review provider. We are a patron sponsor for the Rabiej Litigation Law Center, and we have been a fan of John's for a long time. We have been a sponsor of him for quite a few years. We sponsor John and his activities because we think he's willing to tackle the difficult and tough issues, such as the subject matter for today's webinar. And I hope you enjoy it. And John, why don't you kick it off?
Thank you, Tim. Hey, my center is pleased to hold this first of 3 webinars with TCDI, a longtime supporter. For the past 10 years, the center, as well as its predecessors at Duke and GW Law Schools, has brought together more than 200 federal judges and hundreds more plaintiff and defendant lawyers to develop practical solutions to problems caused by litigation practices and procedures. Now, before we go further, one logistical note. For those of you seeking CLE credit, at some point during the webinar, I will ask you to type in a word and your name in the chat box on your screen for CLE credit. That chat box is the same box that you can use to submit any questions during the webinar. After the summit, we'll forward you the CLE certifications and other information. Now, today we address the meaning of relevant and how it causes excessive discovery. Excessive discovery is not a new problem. Since 1983, Rule 26 has been amended 3 times by narrowing the scope of discovery, requiring proportionality, promoting party cooperation, and encouraging active judicial case management. Now, these 4 rule initiatives have helped rein in excessive discovery, but at least in mass-tort MDLs, the problem has gotten worse, not better, with millions of documents produced in at least 7 MDLs. Technology should help, but Rule 26 takes no position on which search tool should be used because such tools quickly become outdated. Now, left to their own devices, lawyers rely on dated and over-inclusive keyword searches and produce millions of documents in discovery, a large number of which is virtually useless. Lawyers use keyword searches not because they oppose AI technology, including TAR, but because they have little confidence in its results if the opposing side exclusively trains it. Now, the source of this distrust is today's main topic. TAR is trained on documents that a human classifies as either relevant or not relevant. After a certain number of documents are inputted into the machine, it works on its own based on those documents and ranks all documents in order of significance on a scale from 0 to 100. AI generative search tools are quickly eclipsing TAR. Instead of a series of relevant documents inputted into a machine, a series of prompts or queries are inputted into the AI generative model. In both instances, however, human training based on subjective judgments on the meaning of relevant is required. Now, under present practices, only one side usually trains TAR, using documents based on its understanding of the meaning of relevant. It should surprise no one that if there is no common understanding of the meaning of relevant, the results won't be trusted, and lawyers will continue to turn to traditional keyword searches, though over-inclusive, as the preferred search tool. So the threshold issue is how uniform is the meaning of relevant. We won't debate which meaning of relevant is the best. We only aim to see whether there is any uniformity. We look first at the committee notes to Rule 26, which explain every amendment since 1937. Surprisingly, there is little in that long history on the meaning of relevant. There is the reference in the 1946 amendments, which says that the purpose of discovery, quote, is to allow a broad search for facts, the names of witnesses, or any matters which may aid a party in the preparation or presentation of his case. And then there is the 2000 committee note, which explains why Rule 26 was amended to narrow the scope of discovery from relevant to subject matter to relevant to any party's claims or defenses. Now, perhaps the meaning of relevant is too obvious and everybody understands it, or perhaps the meaning is too subjective to even explain it. Now, we have an extraordinary panel of experienced lawyers, judges, and experts who will share with us their meaning of relevant from their individual perspectives. Now, their bios are posted on the center's website at rabiejcenter.org. So we have Jennifer Greenblatt from Goldman Ismail, and she'll give the defendant's perspective. Paul Doolittle from Populin, Willie, and Anaspolo, the plaintiff's perspective. Jennifer Andres from TCDI, the discovery service provider's perspective. And Judge Vaughn Walker, the judge's and special master's perspective. But we begin with Judge Paul Niemeyer, who sits on the Fourth Circuit Court of Appeals, to help us understand the thought process of the Civil Rules Committee. Judge Niemeyer chaired the Advisory Committee on Civil Rules in the year 2000, and there is no one better than he to recount the committee's history. So, and with that, Judge Niemeyer, can you talk about the committee's thought process on the meaning of relevant?
Thanks, John. May I begin? All right. First of all, I'd like to note that John Rabiej and I go way back. We worked together on the Rules Committee, and he was the structural support of the entire committee. And so he probably knows more than any member of the committee what we were doing over those years. John has given us a subject today centered on the meaning of the word relevant when defining the scope of discovery under Rule 26. This is especially difficult subject. The word relevant is a very broad word. It's closely related to the word related. It has some causal components to it, and it means a lot depending on what the object of the word is. It is also difficult now in the context of this exponentially expanding discovery based on electronic discovery. And I am going to suggest a little later that perhaps the practice of discovery has long bypassed the word relevant to accomplish discovery on a more pragmatic basis as computers can be programmed. But I have some views I'll share with you on that. But first, I think it might be appropriate to do a little bit of history. Before 1938, the functions of giving notice of claims, forming issues, and revealing facts was all performed by the pleadings, albeit inadequately, and very little discovery was available. In 1938, the new Federal Rules of Procedure and an entirely new procedural philosophy took hold. Pleadings were restricted generally to giving notice, and discovery was expanded to serve the role of defining issues and revealing the facts. This was understood to be a major shift in procedure, and at the time, it was understood to be experimental. But thereafter, for some 30 years, the scope of discovery and its importance increasingly expanded. This was done by the 1946 amendments to the rules, and perhaps even more so by the Supreme Court's decision in Hickman versus Taylor. Let me share with you an important quote from Hickman. You probably all remember it. This is the quote. "The federal rules of civil procedure are designed to enable the parties to discover the true facts and to compel their disclosure wherever they may be found. It is said that inquiry may be made under these rules epitomized by Rule 26 as to any relevant matter which is not privileged." The court went on to say, quote, "We agree, of course, that the deposition discovery rules are to be accorded broad and liberal treatment. No longer can the time-honored cry of fishing expedition serve to preclude a party from inquiring into the facts underlying the opponent's case." The bar loved this, and discovery continued to increase over the next 20 years, not only in scope, but also in purpose. Moreover, while discovery had originally been controlled by the courts, it was now given to the adversaries to use on their own initiative as they chose. In confirmation of this new outlook, the Rules Committee amended Rule 26 in 1970 to read, and I'm now quoting, "Parties may obtain discovery regarding any matter which is relevant to the subject matter involved in the pending litigation." Relevant to the subject matter involved in the pending litigation. The rule went on to explain, "It is not ground for objection that the information sought will be inadmissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence." This is indeed broad, and the Supreme Court piled on. In 1978, it decided Oppenheimer Fund versus Sanders, where the court noted that relevant, as used in Rule 26, should be construed broadly. Quote, "To encompass any matter that bears on or that reasonably could lead to another matter that could bear on any issue that is or may be in the case." Listen to this definition of relevant. I don't know why it has never been overruled. It's to be construed broadly to mean, quote, "To encompass any matter that bears on or that reasonably could lead to other matter that could bear on any issue that is or may be in the case." Relevant, thus, was understood to reach even to potential changes in the case's issues that might later appear. The gates were open, Pandora's box was open, so to speak, and the curses abided. First, discovery became the major cost in litigation. Indeed, a RAND study conducted later, while I was chair of the Rules Committee, concluded that in cases where discovery was used, its costs represented the vast majority of the costs of litigation. Studies like this and ones done by the Department of Justice and other organizations elevated discovery to an issue of public policy discussed at the highest levels of government. I even remember President Reagan complaining about discovery and its cost. In addition, discovery started to be used as a tactical weapon, a mechanism for delay and oppression of the opposing party. This abuse also prompted responses, this time with respect to the rules of ethics. By 1980, the Rules Committee began to recognize the problems of cost and abuse and began to study how to address them. In 1983, the committee, noting that, this is a quote from the committee, "Excessive discovery and evasion or resistance to reasonable discovery requests pose significant problems." And the committee made a rules change that gave district courts tools to address those problems. But the scope of discovery remained the same. The approach was not unlike a situation where we unleashed a wild animal, and instead of attempting to recage it, we only adopted measures to tame it. Finally, in 2000, the Rules Committee did make a change to the scope of discovery in Rule 26, eliminating the party's ability, I emphasize the party's ability, to obtain discovery related to subject matter of the action and restricting them only to discover relevant to evidence relevant to any party's claim or defense. So the change was from relevant to subject matter of the action to matters relevant to the party's claim or defense. The courts, however, were still left with the authority to authorize discovery relevant to the subject matter. The idea was to give courts more control, and the hope was that while the lawyers might not appear to appreciate the subtlety of the 2000 change, the idea was to give the courts the authority to regulate the change. As you may recall, in the beginning, all discovery was regulated by the courts. And this was a notion to do two things. One was to try to limit the scope that the attorneys themselves could initiate to relevance to a claim or defense, and to authorize the courts to give the broader discovery if it thought appropriate. Finally, in 2015, the Rules Committee eliminated the court's authority, thus limiting Rule 26 to discovery that is, quote, relevant to any party's claim or defense and proportional to the needs of the case. In short, even though the broad, virtually unlimited scope of discovery was narrowed to discovery of matters related to the party's claim or defense, one would have thought that costs and abuse might have been somewhat mitigated. But the story of reality is a different one, which other members of the panel will speak to, I think, both from the plaintiff's side and the defendant's side. And this is especially now in the age of electronic discovery, which has changed everything. Despite the changes in rules, discovery today may be, in practice, even broader than matters related to the subject matter of the litigation, and perhaps broader than the almost limitless definition given in the Oppenheimer case. We'll discuss that more today. What is clear to me, however, is regardless of how we come to understand the word relevant as a limit in Rule 26, the scope of discovery will now be guided by the practice of computer searches and not by the degree of relevancy. Now, a few personal observations that I'd like to overlay on this. First and most important, I believe that discovery is far too expensive a procedure for justice, making litigation overall far too expensive. This is a thesis that I have been advocating for years, and at one point we tried to address it, but my time limits on the Rules Committee ended. The command of Article 3 is to resolve cases and controversies, presumably for all people, not only to those who can afford the discovery, and small businesses and individuals will be unable to participate in such litigation because they can't afford discovery. This is, my view, something that we must do more drastic than tweak the word relevant. That said, in the current regime in place, I would encourage district courts to interpret the word relevant narrowly, although the Supreme Court earlier said broadly, but I think the telegraph from the Rules Committee now might justify using the word narrowly, so as to include only matters that are directly relevant to claims or defenses of the parties. Now, what that would do is certainly leave out some peripheral documents from discovery, but in my judgment, complete 100% discovery is not the answer to justice, and the elimination of peripheral documents will not, in my judgment, change the outcomes of cases, but it will save costs. But observing what is going on in large commercial cases, especially class actions and multi-district litigations, I am not sure a change in the rules or their interpretations will accomplish much. And this is not because the rules are ignored. It is because the need to use computers in order to search large quantities of documents, now mostly electronic, rather than having the luxury of a lawyer making a Rule 26 judgment as to each document reviewed, we are now left to instruct a computer with a program to identify relevant documents. That, as a practical matter, broadens discovery beyond relevancy with the hope of finding relevant documents. As I say, you'll hear more about this from the other panelists as to what is going on. But I suggest that the discussion of relevancy, with all my greatest respect for Mr. Rabiej, may now be irrelevant. And that the good management of discovery requires us more to focus on what computers can do and what they reasonably should do. Of course, the next chapter is even more difficult as we begin to use AI. And that's a subject that I fear to consider. And perhaps that defines me as a Luddite. Well, John, that's it for me. I've probably gone too long, but the subject matter is very interesting and extremely important. And I thank your Litigation Law Center for addressing this. It is indeed one of the most difficult problems for American litigation, in my judgment.
Well, thank you very much, Judge. That really sets us off really nicely. Let's go to the defense side, and I'll ask Jennifer Greenblatt, from your perspective, what does relevant to any party's claims and defenses mean, and how do you apply it in your cases?
Sure, and thank you for having me, and thanks for it's a hard act to follow now, having following up on the great discussion about sort of the history of the word relevant and its role in the new in the relatively new version of the rules. So from the defense side, I think that the word relevant does work, if at all, in the context of figuring out what cadence and order discovery will be done. So one of the ways that you can get away from sort of pointing out, well, look, relevance broad, and there's always, to the peripheral point, a way to make it relevant by claiming that you need this discovery or that discovery to explore bias or perhaps punitive damages or the like. I think that one way that it really does have meaning and does work is at the outset figuring out, should you, for instance, decide a motion to dismiss that might render broad swaths of claims and defenses irrelevant. So, in my experience, that is a way that relevance does do a lot of work. In the old version of the rules, you might not need to know what the outcome of a motion to dismiss, a big one, is, because quite frankly, you don't need to know that in order to know that everything asked for is still within the subject matter. However, if you, for instance, have a big case where there's going to be a large quantity of discovery directed to a claim that is vulnerable to a motion to dismiss, having discovery at least wait for that resolution does have the potential, in my experience, to greatly narrow what needs to be done. And in that way, relevance does have a fair amount of weight. John, to answer your question, what do I think of relevance? Having had the pleasure of working with the folks on this panel thinking through that, I do think that my own view and the view of, I think, a lot of defense side lawyers that do trials is that it likely overlaps with the Federal Rules of Evidence 401. And the problem with that is relevance is only as narrow as the other side's creativity, right? So who am I to say that whatever is being asked for by the other side is truly irrelevant in the broadest sense to any defense, any claim, right? Particularly thinking forward to a potential trial, and there is unfortunately increasingly few of those. People's credibility is relevant to a claim or defense, and there are just a number of things that it's hard from the defense side to sort of do battle in the relevance definition sphere versus, sort of taking the approach that at the outset, we're going to be thoughtful about motions practice ordering. At the outset, we're going to be thoughtful about whether there is a reason to stage discovery to do, for instance, general causation discovery in a large MDL. That might greatly narrow what's at issue in the claims and defenses versus, just everybody have at it, any claim and defense is on the table. I will say that my experience in commercial and antitrust cases, there's a broad scope of what's relevant there too. my experience is that perhaps there's a little bit more discretion used on the other side in seeking materials insofar as large companies going up against large companies. There's sort of a mutually assured destruction if we all take the view that relevance is, in the mind of the beholder, right? So there, I do think that there's a little bit more of a incentive to keep things more contained than they otherwise might be. And I will say that a tool that I think is underutilized in the rules that's related to relevance is sort of the cost shifting principle, particularly when you have some of these large MDLs where even though they're individuals on the plaintiff side of the V, in fact, there's a fair amount of funding and structure there. And so to the extent that you're getting towards the end of discovery, for instance, and there's that request for the 21st, 22nd, 40th, 50th, whatever the number of custodians or sort of peripheral hunting is going on, I do think that it can be helpful to at least have that tool on the table to say, listen, if you truly need it, you might need to pay for it. Because I do think that perverse incentive is there, in the American system where you don't have the parties asking for the documents, asking for the depositions, asking for the additional discovery, directly bearing the cost of completing that discovery. And so I know that was mentioned in the committee notes, and I do think that having that tool paired with some of the others is really doing a lot of the work that the definition of relevance so far has not been doing. Let me pause there. I don't know if John has questions or if folks have questions on this particular topic from the defense side.
There is one question. So one of the initiatives that the rules committees came up with to address this problem was to promote and urge the parties to cooperate more. They came up with the Rule 26F meeting where people were supposed to discuss the issues. Now that's had some success, but as we see in the mass-tort MDLs, it really hasn't been that successful. What if the parties were required to jointly train the computer, either TAR or an AI? And in that case, there would really be forced to talk to each other, and they would then have a series of documents where they could see what, in the eye of the beholder, relevance is. So then you would learn what the plaintiff is thinking, and the plaintiff would then know what you're thinking about. What concerns would you have right now with joint training? And do you think it's likely impossible to come up with a way to meet those concerns, and so that we could come up with some kind of joint training where both parties up front can reveal what they believe relevant is?
It's a good question, John. I mean, I think that something like that would almost be more practical farther into discovery, right? At the very start, it's extremely hard for either side to be very committal when it comes to what's relevant and what should or should not be tagged as relevant, just because there is this asymmetry as far as what people know, right? The party whose documents are being explored knows more than the party who's making the requests. I think that happens at a very rudimentary level right now, insofar as sometimes there's discussions around what level of confidence you need, right? Like, how confident do you need TAR to be as far as whether a document is relevant? Like, can you agree that if it's 95% catching relevant versus irrelevant documents, however that's defined, is that going to be satisfactory? Because there's never going to be a perfect process. I do think that keyword searches, for as sort of blunt of a tool as those are, does sort of, John, lead to the discussions around what is relevant, right? Like, why are you asking for that term? Why do you think that term is relevant to the claims or defenses that you're bringing? And I do think that everybody would be benefited by having more communication, so long as everyone is taking the same view, which is we're not going to be hunting for the peripheral documents that, while technically relevant, would greatly expand the costs and are extremely unlikely to lead to actually usable material.
Great. Well, let's move over to the plaintiff side. And we'll ask Paul Doolittle, from your perspective, what do you think relevant means and how do you apply it in your cases? And you're on mute. Paul, you're on mute.
Thanks for pointing that out. I failed to recognize that a lot. Thanks for having me, John. Thanks, Judge, for the introduction. Jennifer, good to see you, and everybody else on the panel. Yes, from the plaintiff's perspective. I've been doing plaintiff's work for 30 plus years. I had a benefit of doing asbestos litigation for many, many years. I've tried lots and lots of cases. I've been benefit of trying a lot of cases. So my perspective comes from the courtroom, right? What do I want to do in the courtroom? What do I need to prove? What do I need to see? What do I need to get? So from nursing home cases to asbestos cases to whatever case that you're actually trying, the goal is, right? First of all, when you're doing discovery, to me, start with the goal. What's the goal? I want to convince the jury that my side's right. So I don't want discovery, and I don't want relevant discovery that doesn't get me there, that doesn't help me convince that jury of what it is I'm trying to prove. So a lot of plaintiffs, from my perspective, jump into discovery and just send general discovery requests, just generic ones, and not tailored to the case or anything else. And, a lot of times we end up fighting for hours and hours over a generic discovery request that, when produce the documents, there's nothing I can use there. There's nothing that's sexy. There's nothing I'm going to show a jury. So I've wasted my time. And as a plaintiff's lawyer, we do not get billed. We don't bill by the hour. So I've just lost that time that I could have spent on a golf course or reading a book or something else. So from my perspective, it's important to hone your discovery request and to make sure that what you're looking for is relevant, first of all. So don't send the broad things. Don't send everything out. And look at it from a cost time perspective, because relevant to the plaintiff's lawyer, of course, is we want it to be everything in the world. I mean, one of the things you asked me in your outline was, what's the meaning of, the previous meaning of reasonably calculated to lead to discovery of relevant documents. I've said that a billion times in court. I never knew what it meant, and didn't matter what it meant, because what it meant was I'm trying to get this document in. As a mentor of mine, Ron Motley, used to say, we were in trial one time in Houston, and he said, they were claiming prejudicial value outweighs probative effect. And Ron looked at the court and said, well, Judge, if it didn't hurt him, I wouldn't be trying to introduce it into evidence. I mean, so from a standpoint of my perspective, relevant is everything that you can get your hands on that's related to something you're doing and what you want to prove. So that's the first perspective. What do I need? What do I need to show the jury at the end of the day? What do I need to do to win? The other thing is, when winning, I have to remember that after I do my plaintiff's case, the defense has an opportunity, and I need to know what it is that they're going to do. So in discovery, also, the relevant documents to me, what I want, are the ones that are going to address the defenses that they're going to raise, so that I can argue those defenses and be prepared for those before I actually show up in the courtroom. So again, from relevant, from a plaintiff's perspective, and I know it drives my cohorts on the defense side crazy, is everything in the world, tempered with remembering that you don't get paid for that. You could end up paying for it as the cost shifting provisions come into more play. But just on the one side, you paid for it to review it. You're paying people to go through the documents, and you're paying for storage of that document in some kind of document management system. So from the plaintiff's perspective, don't cost yourself money where you don't need it. Fight relevancy where relevancy is important, but don't fight each one. So to me, relevant is a very broad term, but broad in the sense of what am I trying to accomplish in this particular case? Not every litigation, but this particular client on this particular day when we look at that particular jury in that particular jurisdiction.
Well, one of the problems in the mass-tort MDLs, it's a little bit of a different animal than from a typical cases, in the sense that you're right. In the typical case, the plaintiff, there's a cost factor there, and they don't want to, the money you spend on discovery is coming out of your pocket. In a mass-tort MDL, underneath the current structure, there's a lodestar where there's a common benefit fee, and the lawyers are actually paid on the hour. And so they, when we see the records coming in, there's lots of hours reported on reviewing discovery. And that's one of the problems that we face in the mass-tort MDL. There's a financial incentive that you don't have in a typical case.
Only if we win. We only get paid in that situation only when you win.
That's correct. Would you have a problem, or if you had joint training and using AI or TAR, and you were able to work with the other party at doing an appropriate time, taking into account what Jennifer said, that you need to have some understanding of the case. But if we push that up, you have joint training, you come up with the results, would you be satisfied with that, which seems to be consistent with what you're looking for, just the relevant stuff that would be helpful to your trial? Or would you still insist on keywords because you want to make sure you get you want to make 100% sure that you never missed anything?
I think the key to that is, you said you're working with somebody reasonable. And I believe that when you have this perspective, you've got, plaintiff's lawyers, you've got the crazy person on one side, and defense, you've got the most ultimately conservative person on the other side. Most of those times, those people can't work together to come up with a reasonable search protocol that would produce all of the relevant documents, certainly anything you're ever going to use in preparing or in introducing into evidence. And that's the crux, right? Is how do you get people to work together? I certainly believe that Jennifer and I could probably sit down over a lunch and work out some search terms that in any particular case that we were both comfortable would reach 95 to 98% of the results that the old-fashioned way would do it. Produce every daggum thing in banker's boxes, and we'll get out our little sticky pads and start making notes and copies. So I believe it's incumbent upon the players that are involved to be reasonable. And I think on my side of the point, there's plenty of plaintiffs' lawyers that I know that are completely unreasonable, demand the world. They have strategies for that and ideas of why that's good tactic. None of them make any sense to me, and I've always discouraged them whenever somebody brings those up. So I do think it's possible. Whether or not we we achieve that ultimate success is probably more relevant, more depending on who the parties are, who the individuals are.
So we're faced with in these mass-tort. It's in the in our materials. We have 7 reported mass-tort in the record that there's more than 2, 3, 5 million documents actually produced. That's what the language in the actual record. Do you find that to be, just looking at the numbers, every case is different. There's obviously factors and all of that. But do you find that to be a problem? Because I want to see whether or not the entire bar and judiciary senses there's a problem with 2 million documents being produced. I do, but I'd like to get confirmation from both sides, basically.
There's a problem. It's a huge problem. I'll tell you, Dan, as y'all know on the panel, I did tobacco litigation for many, many years. We represented the attorney generals in the states fight with Motley Rice. I was a partner there. And then that's Motley Rice days. We too many documents. We had, I don't even remember the total number of documents, but we had 250 staff members and 15 lawyers dedicated to nothing but the tobacco documents in our firm alone. That's in combination with firms across the country in every single state had their own section of that. So millions of dollars spent on the documents. And I can tell you, when I would do a deposition, out of those truckloads of exhibits that would come in, I would use 30, maybe 70, and then those probably are not even going to be relevant for trial at that point. So vast overuse, vast waste. And that cost the plaintiffs money because, at that point in time in tobacco litigation, we were pouring money down an empty hole and nobody had ever prevailed. So, we had plenty of partner meetings discussing the cost of this exorbitant cost of managing these documents and, what are we going to do about it? And so I do think it's the technology today is going to help us both combat that cost. Because on the other side, for the defense, to be fair, it's exorbitant as well. Some of the numbers that we've discussed are just astronomical. Frankly, I had no idea it was so expensive on the defense side.
Well, thanks a lot. Then let's go over now to Jennifer Andres and let's hear from the discovery service providers' perspective. They're the ones the clients ask them to produce or to identify and then produce the relevant information. So, Jennifer.
Great. Well, thank you for having me. For our team, it's a little bit tricky how we want to define relevancy because we work at the direction of counsel. So when we're working with a Jennifer and a Paul, we rely on them to tell us for that particular matter what is going to be relevant, which means it's also changing from project to project, and it's never going to be, a finite definition. There's never going to be that one easy answer. So what we do is we work with counsel at the outset of the project to define relevant and how are we going to apply that standard? Are we going to be broad? Are we going to be narrow? And to kind of point out what Jennifer mentioned before as well, oftentimes at the beginning of the review, that means something completely different than when you've ended the review. You find out so many more things while you're in the documents, and that's just a changing and evolving criteria throughout the matter. That it's hard at the beginning to really say, how does this apply and how are we going to make sure that we're hitting it with that 100% accuracy target that everybody wants to hit. So what we do is we work with counsel to really define these terms at the outset as best as we can based on what we know. And then we work with our teams to make sure that we're applying the threshold how it at that time should be applied. Then as we get through more documents and we get a better understanding, we continue working with counsel and saying, hey, we see this. We think this maybe changes that definition, or we think it changes how that scope should be applied. And throughout the project, having those conversations with counsel and really flagging those items that we think maybe changes the criteria or the standard really helps shape how we end up seeing relevancy for a particular project. Think that's really the high level, but like Jennifer and Paul both said, it's really going to just depend on the facts of the case. Oftentimes that's how we start. The protocol will outline all of the high level detail of the matter to include any causes of action that they're looking for, things like that. It's going to give a bit of procedural posture, and then relevancy almost just sometimes is if it's related to anything that's been talked about before this section of the memo, then it makes it relevant. That's sometimes how we end up starting. And then again, as the review progresses, that's when we start to maybe be able to narrow that a little bit and kind of hone in a little bit on what that relevancy term should mean throughout the remainder of the review.
Nice. So does the client provide you with a checklist? In these mass-tort MDLs, they typically have like 15 to 17 major counts: negligence, strict tort liability, misrepresentation, fraud, and there's about 20 in general. Are they providing you for each of those major counts some kind of guidance, or they just provide you with the pleadings and you got to figure it out?
We work off. Yeah, we work off of protocols, which are in essence the checklist that you're talking about. Basically, it's going to have some case overview and background, so it's going to give some facts of the matter, and it's going to really talk through those causes of action, those different items that would be on the checklist, and what we want to be on the lookout for, and it's going to really highlight where we should focus on those and how we should interpret them. So all the different causes of action, it's going to say that the opposing side is alleging this. We want to look out for it in this way. If it talks about it in this manner, it's going to be relevant. That's how we typically will work off of something like that. And then using those facts and procedural posture mentioned to kind of give us some context as to how to apply those as well. Sometimes they do provide the pleadings, and in those instances it's helpful and we can get a little bit of additional context. But we like the protocol and that checklist kind of that you're referring to because it gives us more of a high level summary and allows us to kind of go from a summary view instead of reading through 90 different pleading files to kind of get a sense of what it is that they're looking for and how they want that standard to be applied.
Just one real quick one. Have you started, or is TCDI, I know I've spoken with Bill, you guys have started AI, the generative, how many prompts in the case, how many prompts are you talking about? We're talking about 500 documents, 1,000 documents that's fed into the machine. In AI, there's on the prompts, these queries. How many queries? I mean, I know every case is different, but is there any kind of general number? Is it a few, or is it hundreds, thousands? What's been your experience?
Yeah, so for the generative AI, it's really how you train it and how well you put the facts and the knowledge together for the system to learn and train off of. It can be pretty detailed, but Gen AI, the whole part of it is just how simple and plain language you can make it. And that's going to determine the results that you have. So a lot of time is spent at the front end, really, prompting the machine, getting it to learn and understand what it is you're looking for and how you want those bases to apply. It's always recommended to start on a smaller population and then calibrate that, train it, run the prompt, see how well it does on its own coding. Take a look at the results and see how you feel about those. Or is it, hitting what you would expect? Is it you missing things? Do you need to calibrate it? If you need to calibrate it, then you just want to go through and update what you've used to train the system. So if it's missing things, do you need to change a definition? Do you need to add some additional context for something that it may not be understanding as potentially relevant? You really want to assess how it's coding the way it's coding and then how to improve that. And then again, once you've made an improvement, run another iteration. See how that changed. Did it change for the better? Did it change for the worse? And then you kind of have to play the game of, okay, so now how do I make this piece better? Or how do I go back? Because it definitely, it did worse. So we need to at least go back a step and then improve it from there again. So with Gen AI, it does take some work at the beginning and really making sure that it's understanding and training the way you'd like. And then just honestly, the number of iterations it's going to take in order to get where you feel it should be at and the comfort level you would be with human review on those documents before you then run it across a larger set of documents. I've seen as few as 2 to 3 iterations, and I've definitely seen a lot more. So it's going to be based on the complexity of the case, the number of things you're looking for, the types of documents you have, those types of things.
Great. So on probably the third webinar, I'll probably get back with you if you're the speaker for TCDI and ask what problems, concerns, and is it even feasible to think about joint training of this Gen AI machine doing the prompts, keeping in mind that it's work product and attorney privilege that they're going to be concerns with, but are there ways to get around that? I think they are with TAR, but that's another discussion. For those seeking CLE credit, please, this is your moment that you have to do some action to be eligible for the CLE credit. So please type in the chat box, please type in your name and the word RED, R-E-D, in the chat box. And then we'll know that you actually attended this webinar and you'll be eligible for CLE credit. So now we get to Judge Vaughn Walker, and the judge will give us, as a former judge and now he's got his own practice. He's a special master and wears many other hats. So from your perspective, Judge, and you've got such a wide and long history, give us what you think relevant and what it means to you and how you applied in your practice and in your experience.
Well, thank you, John. It's a pleasure to be with everybody. I apologize for not having a video for some reason or other. I don't know why it didn't work this morning, but it didn't. Paul's observation put me in mind of being a lawyer many years ago in a courtroom when I objected to some evidence coming in by the other side on the ground that it was prejudicial. And the judge looked at me and said, "Mr. Walker, nobody's interested in evidence unless it's prejudicial." And that's very true from one side or the other. Now, I'm going to embark on an area that Judge Niemeyer wisely, perhaps, avoided, and that is the subject that Jen mentioned of iterative alternative intelligence, or AI. It really is impossible in this day and age to avoid that subject. Even the recently installed Roman Catholic Pope weighed in recently on AI and expressed his apprehensions about the good and the bad that could come of it. So you can't avoid that subject, and you can't avoid that subject in this context either. But despite its apparent novelty, the essence of AI is something lawyers and judges have been dealing with for a very long time. I think our discussion so far has already highlighted that point. And the subject that just happens to be the subject of this webinar. So let me see if trying to weave in a discussion of AI into this discussion might be somewhat helpful. The goal and purpose of artificial intelligence, at least as I understand it, is the functional understanding and expression of language. Now, language, of course, enables us to comprehend, express, and communicate concepts and ideas. Language separates us, Homo sapiens, from other mammalians on Earth. Without highly developed language, we would all still be swinging from trees somewhere in Africa. After all, humans are not the only creatures to have migrated from Africa to the Eurasian landmass and to the Americas. But Homo sapiens took with them language and grammar in the way that these other creatures did not. Words and grammar are really the heart of language, and words and grammar are the grist for the lawyer's mill. Words and grammar are also the grist for the large language models of artificial intelligence. Facts and laws are expressed in words and grammar. Words and grammar are the tools with which we understand and communicate evidence. Federal Rule of Evidence 401 calls for the admission into evidence of any evidence that has a tendency to make a fact more probable than it would have in the absence of such evidence, and is evidence that is of consequence in determining the outcome of the action. There is, I submit, little reason to think that AI cannot assist lawyers greatly, perhaps, in deciding what facts, expressed as they are in words and grammar, have the kind of tendency that Rule 401 speaks about. In the argot of artificial intelligence, the selection of words that have a tendency to make a fact more likely than it would have in the absence of such evidence is, in the context of AI, labeled as having interpretability. This amounts to a selection of words and patterns of words that follow the same pathways in machine learning, that is, the same or similar to the neural pathways of the human brain. We tend to think that much judicial decision-making is a kind of an inscrutable black box. We think about the jury process as being a black box. We think about some of the discretionary rules that trial judges have, where they are afforded wide discretion as something of a black box. Well, the advantage of AI and the large language models that AI uses is that is a way to begin sorting out those factors that contribute to what otherwise may appear to be an inscrutable decision. You might ask, in a way, how I learned about alternative or artificial intelligence. Well, I've learned about artificial intelligence in the same way that I've learned about a lot of subjects. Probably everybody else here has learned about subjects in the same way. You learn about these subjects as a lawyer or a judge, or perhaps both. And one of the rewarding aspects of our profession is it brings you in touch with what's going on in the world in a way that very few other professions experience. And everybody knows, if you've been around a courtroom for a while, that there are a lot of things that matter in a courtroom that are never admitted into evidence. A lot of things would never pass the test of admissibility, but nevertheless they do matter. These influences are palpable. We just don't talk about them. In fact, we usually deny that these facts exist. This is a kind of a conceit or illusion. It's considered, at best, bad taste to talk about them. A glaring faux pas in this regard was when Justice Tom Clark, in the United States versus Estes case dealing with cameras in the courtroom, said, quote, "Those of us who know juries realize the problem of jury distraction." It's hard to argue with a judge who says, "I know from my experience, thus and such." And of course, Potter Stewart famously said in the Jacobellis case versus Ohio that obscenity cannot be defined, but I know it when I see it. There are, in fact, a lot of things that go into the determination of what matters for purposes of a decision that don't meet the test of admissibility. But artificial intelligence has a way of highlighting those factors in a way that human dialogue and lawyer argument cannot. With the exceptions of Justice Clark and Stewart, much that goes on in deciding relevance is never articulated. While evidence codes and treatises may be long and detailed, there is, as actress Doolittle Bankhead said, there's more there than meets the eye. There's a lot more that meets the eye in what matters in terms of outcomes in court. And AI proves this point. In determining what goes into a decision about what is pertinent to an AI determination of meaning could never pass a test of admissibility. The large language models of artificial intelligence use a vast quantity of data, only a portion of which would pass a legal test of admissibility. The trick in applying this tool or these tools is determining what is fed into the maw of a large language model, which after all trains itself. Large language models measure the size of the training corpus in tokens, with each word comprising one or more tokens. These tokens allow the large language model to recognize patterns in language, to generalize how language works, and interpret prompts and produce original outputs. Tokens are words or portions of words in numerical form. Each token is assigned a number from which the token dictionary provides a weight to determine its significance. The tokens are grouped in sequences, which are randomized for training, and then grouped in vectors, which are numerical values to capture meaning, the relationship of words to one another, along with grammatical properties and other characteristics to approximate human language. The process by which these large language models do this is quite similar to the test of relevance as used by human beings. At its heart, relevance in life and relevance in law is predictive. Perhaps this is not always predictive in a causal effect way. Sometimes it's simply predictive in an association way, but it matters nonetheless. There are many ways in which we can think about relevance. Most of them are not definitive. They hinge on context and understanding. Like so much in our profession, there are no bright lines to test what is relevant. Justice Holmes said, the life of the law is not logic, it's experience. And what we can do with artificial intelligence, with the robust capability that it has, is to feed into it vast quantities of information. And out of that process comes rules and associations that we never would have thought of as individuals, but we can use those in testing hypotheses, hypotheses on the plaintiff side, hypotheses on the defense side, and hypotheses for a judge to help make a decision. This is really, I think, a groundbreaking tool that will help us decide what really matters in terms of what is relevant, what is not relevant. It's a way in which we can begin to get our arms around this vast quantity of data and information that Judge Niemeyer spoke about. And without this tool, the whole system would at some point or other come to a screeching halt. But I'm very optimistic that with artificial intelligence, we can begin to tackle what matters in terms of relevance in a way that we have never been able to do in the past.
Well, thank you very much, Judge. And that 60 minutes just went by so quickly. I want to thank all the speakers for a wonderful and thoughtful discussion. Also want to thank TCDI for the opportunity to present this webinar. Thank you very much, Tim. We will hold 2 more set webinars that build on this one. The next one will focus on how the requesting party manages the review of millions of documents produced in discovery. And a final webinar examining how TAR and AI generative tools can be jointly trained with minimal and protected disclosure of non-relevant documents. Please check our website at rabiejcenter.org. It's updated regularly. Notices of the webinars will also be circulated. Thank you for attending the webinar. Please consider registering for the Center's mass-tort MDL Summit at Northwestern University on July 10, when 15 judges and 30 lawyers and other experts will carry on this important discussion, which will lead to the drafting of best practices. Registration can be done also online at rabiejcenter.org. Thank you all and have a wonderful day. Really appreciate it. Bye now.
Thank you, John.
Thank you.